Welcome to literary and jury charge practice. Let's get started with some jury charge. Ready? Here we go. After a hearing, the Massachusetts trial court denied relief, holding that the newspaper publication provided for by Section 26 was sufficient notice of the commissioner's proceedings to meet the requirements of the Due Process Clause. Agreeing with the trial court, the state Supreme Court affirmed. The only question we find it necessary to decide is whether, under circumstances of this kind, newspaper publication alone measures up to the quality of notice the Due Process Clause of the 14th Amendment requires as a prerequisite to proceeding to fix compensation in condemnation cases. It cannot be disputed that due process requires that an owner whose property is taken for public use must be given a hearing in determining just compensation. The right to a hearing is meaningless without notice. In Murphy versus Central Bank and Trust Company, we have thorough consideration to the problem of adequate notice under the Due Process Clause. That case established the rule that if feasible, notice must be reasonably calculated to inform parties of proceedings which may directly and adversely affect their legally protected interests. We there called attention to the impossibility of setting up a rigid formula as to the kind of notice that must be given. Notice required will vary with circumstances and conditions. We recognized that in some cases it might not be reasonably possible to give personal notice, for example, where people are missing or are unknown. Hopefully your fingers are warmed up. Let's do some literary practice now. Actually, this is an article we've been working on, and this is pretty much the end of it. It's the title of the article is "You Won't Believe the Job I Just Took." Excuse me. Okay, ready? Here we go. Then a client asked me to accompany him to Kiev and Cyprus for a series of depositions. Daunting but doable. A local university wanted me to report super technical interviews investigating allegations of academic misconduct. Check. I jumped into real time, and last fall I joined 2 other reporters in handling a 2-week daily copy arbitration. 400-page days, with the real time provided by cloud to 40 attorneys in the room and across the country. Woo! And now I have sat for 7 hours without pause to report a 25-page public hearing with over 80 participants and next day delivery. There are days or weeks or even months when I am happy to take the easy jobs. I may even fret and fuss when a real toughie drops onto my plate. But my husband always reminds me that I haven't messed up yet, and I'm finding that every time I rise to the occasion and successfully handle a killer job, the feeling of satisfaction is rejuvenating. All right, let's practice some more literary material. And this article is called "The Probable Secret of Success in Court Reporting School." And it looks like it's written by a student. And this is in our Journal of Court Reporting magazine from NCRA. The probable secret of success in court reporting school. Here we go. To gain proficiency in any skill requires a tremendous amount of focus, patience, and discipline. Court reporting is certainly no exception. Court reporting is a skill that not only requires extreme concentration but also encompasses a great deal of physical prowess. I attribute my success so far in the art of learning and performing stenography by comparing it to that of an athletic endeavor. Court reporting students are asked to achieve a whole lot in a short period of time. One must not only learn a new language and develop one's own style within that language, but also must become a virtuoso on their instrument and enter into the business world with an ability level that most likely surpasses any other entry-level position in virtually any other field of business. Sounds scary? It is, and it should be. Becoming a court reporter isn't easy. Success, however, is attainable through organization and having a solid practice routine that touches upon all the elements of machine shorthand. It is these two factors that form the foundation of success that will carry you through court reporting school. As with athletics, a student must not neglect any element of training that will ultimately help them to realize their goals. Let's take, for instance, the sport of weightlifting. It can be overwhelming to enter into the weight room of a fitness center and start an exercise routine that will lead to your proficiency as a weightlifter. What machines should one utilize? What muscle groups should one work? How should one keep track of their progress? Understanding how the body builds muscle is the first objective that you must achieve. It's the equivalent of having a strong foundation in your court reporting theory. In order to devise a solid and organized routine, one must first have the knowledge of the skill to do so. Excuse me. All right, let's get back to some jury charge. Ready? Here we go. Measured by the principles stated in the Murphy case, we think that the notice of publication here falls short of the requirements of due process. It is common knowledge that mere newspaper publication rarely informs a landowner of proceedings against his property. In Murphy, we pointed out many of the infirmities of such notice and emphasized the advantage of some kind of personal notice to interested parties. In the present case, there seems to be no compelling or even persuasive reasons why direct notice could not have been given. Appellant's name was known to the city and was on the official records. Even a letter would have apprised him that his property was about to be taken and that he must appear if he wanted to be heard as to its value. There is nothing peculiar about litigation between the government and its citizens that should deprive those citizens of a right to be heard, nor is there any reason to suspect that it will interfere with the orderly condemnation of property to preserve effectively the citizens' rights to a hearing in connection with just compensation. Notice by publication in too many instances is no notice at all. It may leave government authorities free to fix, one-sidedly, the amount that must be paid to owners for their property taken for public use. For the foregoing reasons, the judgment of the Supreme Court of Massachusetts is reversed and the cause is remanded for further proceedings not inconsistent with this opinion. Let's begin another jury charge, and the subject of this jury charge is income tax evasion. Ready? Here we go. So, excuse me. Ladies and gentlemen, this has been a comparatively long trial as these cases go, and the attention and earnestness which I have observed you devote to it are indeed commendable. You have had occasion to examine many documents, and you will have further occasion, if you so desire, to examine such documents as have been properly received in evidence. So at the outset of these instructions, I wish to congratulate you and to commend you. You have the gratitude and the appreciation of this court for the very serious and conscientious manner in which you have approached your duties as citizens. It is the duty of the court to instruct the jury as to the law governing their deliberations in this case, and it is the jury's duty, unaided by any suggestions from the court, to pass upon and decide all questions of fact. The court has nothing to do with questions of fact. These are matters entirely within your province, and which you as jurors must determine for yourselves. Your power of judging the effect of evidence, however, is not arbitrary, but is to be exercised with legal discretion and in accordance with the rules of evidence. You are not to consider for any purpose any evidence which has, by the order of the court, been stricken out, or the offer of any evidence which has not been admitted by the court. The statements and arguments of counsel, and any purported statement of fact contained in any question asked by counsel of any witness, are not evidence in this case, and any statements made by counsel either during the trial or during the argument, which are not supported by the evidence, or which are inconsistent with my instructions as to the law, are to be disregarded by you. This, however, does not apply to stipulations of fact by counsel, which stipulations of fact must be treated by you as facts proven in the case. All right, let's get back to some literary practice. The probable secret of success in court reporting school. Ready? Here we go. You are in the gym because you want to make your body stronger, but there are many elements that need to be addressed. In order to be physically fit, one must spend an equal amount of time on each muscle group, devote a portion of their day to cardio exercise, and give attention to stretching and flexibility. All of these elements, which, when put together, make up what one needs to be truly successful in the sport of weightlifting. Likewise, court reporting students are faced with many elements that need to be addressed. You have 4 categories to contend with: jury charge, literary, 2-voice Q&A, and multi-voice, each category requiring an equal amount of time to master. Additionally, you must devote a portion of your practice regiment to drill work, finger drills, numbers, dates, times, cities, and states, and a significant amount of time to briefs and phrases, conflict resolution, and proper names. You must allow yourself an opportunity to write at controlled speeds, and you must set aside a time to write at speeds that are out of your comfort zone. You must dedicate a portion of your practice to straight copy material so that you can better identify your hesitation words, and then you must allot an appropriate amount of time to practicing and drilling those hesitation words. You need to consistently reinforce your theory background and properly identify concepts that are giving you trouble. Oh, and to top it all off, you must also become PhD level English scholars, be up on current events, and have a mind for technology that would impress even Mr. Gates. When you stop to think about it, there's a lot of stuff to have on your plate, and if there is one thing I've learned throughout my journey in court reporting school, it's that sitting down and doing mindless dictation is not going to cut it. Organization is the key to making sure you hit every element that you need to become 100% proficient in the skill of machine shorthand. Sorry about that. All right, let's get back to some jury charge practice. And we will finish up our jury charge on tax evasion, it looks like. Here we go. You are specifically instructed to disregard that portion of the opening statement of the government which had to do with certain proposed evidence concerning alleged income in the year 1959, which proposed evidence was later stricken from the record by the court. The court in these instructions in no manner intends you to understand that he is expressing an opinion as to the guilt or innocence of the defendant or upon the weight of the evidence or as to the truth or falsity of any witness in the case or as to any inference you should draw from any of the testimony or as to whether any alleged fact is or is not proven. If the court has at any time during the trial asked any questions, made any ruling, or used any language that has seemed to you to indicate the opinion of the court as to any question of fact, you must not be influenced thereby, but must determine for yourselves all questions of fact without regard to any opinion you may suppose the court may have or entertain. If in these instructions any rule, direction, or idea be stated in varying ways, no emphasis thereon is intended by me, and none must be inferred by you. All principles of law herein given are of equal importance. For that reason, you are not to single out any certain sentence or any individual point or instruction and ignore the others, but you are to consider the instructions as a whole and to regard each in the light of all the others. It is the duty of the jury to determine the issues in this case solely from the testimony of the witnesses and the exhibits that have been introduced in evidence in this courtroom and the law as given you by the court, and not upon anything that you may have read or heard outside of the courtroom. Excuse me. All right, that does conclude that jury charge. Let's read a little more from our literary here. Here we go. I am fortunate to go to a school that takes the concept of time management very seriously. Without the ability to manage one's time, there is no way that one could properly organize the incredible amount of information that is needed to master. It is, in my opinion, the most critical element to making steady progress through the challenge that is court reporting school. Think of yourself as an athlete. You can take a day off every now and then to reboot and recharge, but not at the expense of your overall progress. Of course, life doesn't come at us in strictly black and white terms. You cannot always predict what events will lie ahead that may derail your routine and halt your progress. All you can do is anticipate your day-to-day activities and make court reporting practice as much a priority as anything else. Rather than getting discouraged when you have a day that doesn't pan out the way you had planned, you must get back on the horse the next day and remember that the key to success is always consistency. All right, and that will conclude our literary and jury charge practice.